In the last section, we covered the ternary logic of government, and in this section, we're going to cover the ternary logic of legislation and the ternary logic of the judiciary. Okay, now let's scale that up to the ternary logic of democratic legislation. This is also a key failing of our Constitution to articulate this clearly. This is what I think Scalia may not have, I can't figure out if he understood what he was doing or he understood it only from the court's perspective as he was restoring empirical law. In the logic of the people, the legislature, and the judiciary. And this is interesting, and it's really, I just think it's so core to understanding the American way of life and our American way of government, even the English and Proto-Germanic ways of government, is that there's this balance between the people, the legislature, and the judiciary, just as there was between the people, the captain, and the quartermaster. And that's that legislatures should be elected from those capable of legislating, in other words, producing contracts between the classes. These laws must limit themselves to a range of criteria within the natural law. Unfortunately, this list isn't in the Constitution. It's in the one I've written, but it's not in there, and it needs to be. So all laws must limit themselves to this particular range. They have to be nomocratic, which means they'll all descend from and the demand for the premise of, the logical necessity of, and the natural law of self-determination by sovereignty and reciprocity. And if you can't derive a law from that set of principles, it can't be a law. It can be a command. It can be an aspect of trade within a contract. In other words, there might be some legislative contract, and you're trading this irreciprocity for this irreciprocity because together they perform an exchange. It has to be algorithmic, meaning all acts have to be strictly constructed from a logical sequential test of that reciprocity. This is another way of saying that any nomocratic law has to descend from sovereignty and reciprocity, but it has to be constructed algorithmically. In other words, you have to be able to write it as a proof. Most of what I do does this. So.
This would be calculability, then?
That would be calculability, correct. It has to be isonomic, meaning all acts have to be general rules, universally applicable to all or all within a class, and specific rules not applicable to all within a class are prohibited. There's a long history of prohibiting legislation in the service of or in the constraint of individuals' special interest and interest groups. In other words, most of what this nonsense that came about in the 60s is a violation of isonomy. It doesn't apply to everything. The way the law is constructed is that the legislature or the monarchy can only produce general rules. How the court is the one that applies general rules to individual instances. In other words, the Congress can't make a law granting me a special privilege. The court can, however, find conditions for an exception to a law. The examples would be the discrimination clauses. Discrimination occurs because we want people to conform to a norm. Turns out that discrimination is a very good thing. It's the cheapest way possible of forcing people to adopt to cultural norms, traditions, and values. I mean, religion works by ostracizing people who don't conform to the faith, and discrimination ostracizes people who don't conform to norms, traditions, values, manners, ethics, morals, etc. So it's depriving us of the power to force integration. Because if you go through our history, even if you go into the Civil War era, I mean, there's a black upper class that we've lost. That's not really true. We've lost them in the sense that they've joined the ethnically European upper class, but in doing so they've abandoned their own. What we had at the time of Lincoln is he could go to the black upper class and say, can you get your people to do this? Or what we need from your people is this. They would negotiate with these people, which is essentially treating them as nobility. And this was lost to the black people by the forcible integration attempt. And the reason for the forcible integration attempt wasn't an attempt to uplift black people. It was a copying of the Russian Soviet attempt to undermine host peoples by migrating Russian peasants who were loyal to Russia, not to and were more backward, frankly, in bringing them into more developed Eastern European countries. They did the opposite, of course, which is they took more developed Russians and moved them into Central Asian countries. So that the idea that there was this benevolent goal behind the 60s activity is for those people who don't understand how well they were manipulated during that time period through the media.
It's a very excellent book by E. Michael Jones on the subject called The Slaughter of the Cities, if anyone's interested.
It's an excellent book. I say this all the time, that I have nothing to talk to Jones about because I wouldn't disagree with him on anything, yet it makes the fact that he's talking from a theological perspective, it makes a conversation impossible. So it's not really point talking to him, even though we agree on everything. This is the argument that that wisdom literature can work. The problem is that wisdom literature is more open to failure than science, but it doesn't mean you can't get there with wisdom lit. That's like I said, the Catholic Church screwed up. They had the answer. They just didn't take it across the line. And if they had, we'd have a church still. Anyway.
That was a good little sidebar. I want to thank you for that.
The fourth criteria is that it's internally consistent, what we call stare decisis. Which means that you can't make a body of laws that aren't coherent, such that a person can commit a crime by trying to obey the law, or that there are different conditions. There's a big difference between. See, we use this word law as the body of law, but there's one law, and that's tort, reciprocity. The rest of it's just applied. So we have law, constitution, legislation, regulation, and findings of the court. Well, but most of what we have to deal with that's frustrating is actually bad legislation that can make it into the market before the court has said this is actually legal, right? This is just under our Constitution. It has to, instead, the legislature can say something stupid, and then we have to go to court over it. In other words, there's no guarantee that what the legislature produces conforms to rule of law. Secondly, it doesn't require regulations pass legislation and rule of law. So this is where we get this nonsense when realistically, some parts of a government, if you get down to what they do, they're incredibly well run, but that's because they lack malincentives. If you go into other parts of the government, they're incredibly corrupt because they're littered with malincentives. So, when you read, we pick on our politicians, but if you read legislation, the ordinary legislation that they process for budgets and whatever, it has pork in it and whatever, but it actually tended to be until probably Obama, it tended to be pretty good. If you look at the stuff that we fight over, well, it tends to be really bad. Anyway, our fourth point is that it has to be internally consistent and it has to be logically coherent, because otherwise it's judicially undecidable, and this forces the judiciary into making discretions rather than performing judgments under rule of law. Now, we have to state what it's contingent upon, because while it can be nomocratic, algorithmic, isonomic, and internally consistent, you might create a piece of legislation that conducts a trade. And then at some point, somebody might re-legislate something that removes half of that trade, thereby unwinding the trade that existed before, producing an immorality or an irreciprocity or a violation of natural law. So unless laws state what they're dependent upon, in other words, what they derive themselves from, in other words, it's one thing to build something based on rule of law and then rights and then some application of rights. It's another to say there's some contract, legislative contract, and we have produced some trade, and this is creating a condition in the polity or the economy or the government, and then we're adding or removing criteria to that transaction. And so if that's the case, you have to say, well, I'm dependent upon these prior findings, and therefore I am bound by those prior findings, or we have to understand we've invalidated the previous contract. This is incrementalism. It's the failure to articulate what we're contingent upon. Well, it's not only that, is that to prove to the public that they have the right to do it, right? I mean, and this is the ternary logic that I'm trying to get to, which is that the whole point is that Western civilization is hyper-adaptive. What's the point of the judiciary being neutral? Is it forces the people in the form of their legislature, the jury, meaning the jury, to produce laws that are reciprocal. And in doing so, to transform the population, to maintain adaptivity in the population. It's not to give the population lies, cheats, and steals by popular consent. In other words, undermining our law is undermining the virtue of Western civilization, which is our continuous rapid evolution. The problem is that's not stated in the Constitution. It's obvious if you're to me, it's obvious as a scholar, but it's not obvious to the judiciary or the law schools. In fact, the law schools do everything possible to undermine it. Well, liberalism created the idea that a government should do good instead of facilitate the rules of the game by which the nobility and the people do good. And this is the curse that France brought in. It's not what the British brought in, it's what the French brought in. But that's what French, and then it became amplified by the Marxist postmodernists. So you have this escalating problem of the British middle-class takeover, but not being too bad. The French underclass takeover being really bad, and the Jewish underclass takeover being absolutely horrible. And you have this escalating counter-revolution against the empirical restoration of Western civilization by each culture it's gone through. We're just finishing through the Jewish, what we think of as PC woke. It's the Jewish counter-revolution, but we didn't think of it as the 1800s being our accommodation or failure to adequately resist the French counter-revolution against Western civilization. And before that, we didn't understand that the formation of the nation state, which we consider our wars of religion, was the more evolved people, those up into the Hainal line, trying to exit from the less evolved people, being the Catholics and the underclass. This is just multiple attempts to restore empirical existence as empiricism was restored to our polity. In other words, the original empiricism we evolved under, and which gave us Greece and the glory of Greek thought and the glory of Roman administration and law, and the restoration as the classical knowledge came back into Europe. This all brought about these conditions. And once the British had reformed the modern state, restored empiricism, then there was a sequence of counter-revolutions against empiricism. Now the French tried to make it high and mighty, but they were just a secular Catholic authoritarian counter-revolution. And the Jewish was just, Marxism. Marxism is just Judaism. The same way woke PC is darn near Christianity. So we get these counter-revolutions against us, but underneath it, our original structure of our polity, of our law, is just science. Anyway, so we need to be contingent and complete, which we have to justify why we're going to be successful. In other words,
who's we?
The people who are authoring the legislation, the law.
Okay.
They have to explain why they're going to be successful and the criteria for its reversal. So all acts must state the purpose, scope, and limits of the demands they impose upon. such that they can't be expanded through political, prosecutorial, judicial, or other activism. In other words, one of the problems we have with our law today is they don't state the purpose, therefore they aren't limited. So when in the act of producing a general rule, our judges have to go back into history to discover what the purpose of the law was, where the law's purpose should be stated. We are trying to solve this particular problem, and this is the general rule we're going to use to pursue the problem, and we don't intend it to be expanded beyond this without the legislature making that judgment. What happens in how they abused our judiciary is because that isn't stated, they use creative prosecution of specific cases to the Supreme Court, and this was financed, deliberately done to undermine our Constitution by taking advantage of the fact that these things aren't stated.
Yes, it's interesting. It's like an intentional
subversion. Well, in an effort to make it general, they aren't limiting it, right? And that's because throughout most of our history, things didn't change fast enough. And so we just didn't have this criteria, but we need the criteria because things change faster, and the court is more likely today to be politically subject to political activism. All right, now we have to go to the next section. So I covered nomocratic and algorithmic, and those are the foundations, and then the general criteria, and then we have to do the applied criteria, which is it understandable? I mean, what good is a law I can't understand? I mean, what is this Nancy Pelosi? We have to pass it and then we'll understand it? Well, the reason is that they're not held accountable. For example, why is it that you can propose a violation of natural law without it being a crime as a legislature? I mean, if you voted for a thing that gets overturned by the court because it's contrary to the law, I mean, the court ought to be able to censure the legislature. Before it's released, the law is released, or assent, the assent of law. You know, we have the president can veto it, but we don't have the court go through it first. The court's allowed to be wrong because it can't be omniscient. It can't predict the every future. But, I mean, the difference is you wouldn't have this crap law because you realize our law isn't written by legislators or their assistants. It's written by special interests who then give it to the assistants who go over it and then who tell the legislators to vote for it. So, I mean, we're in the worst possible condition, whereas we have this amazing Constitution that's rock solid. It should be rock solid, except for 6 or 7 or 8 holes, like that I'm mentioning here. Yet there's no way for the court to protect us against it, and the people don't, and the left in particular doesn't want the court to protect, because the left wants to produce authoritarianism because they can't compete in markets. So the law has to be understandable. It has to be adherable. You have to be able to do it, adhere to it. It has to be enforceable. It has to be durable. In other words, it has to survive over time, except in court. It has to be perishable. It has to have sunset criteria. What are the criteria when this would no longer apply? It has to be warranted and warrantable. That means if you sign it, that means you're warranted that it's legal. And if it gets overturned, then you've essentially engaged in a crime. It has to be reversible and restitutable. This is how the left gets away with incrementalism, is they do what's not warrantable and they do what's not reversible and restitutable. How are we going to fix Social Security? It's not reversible or restitutable. So you're going to fix these problems, they have to collapse in order to fix them. And it has to be non-retroactive. So these are the criteria that would be necessary for the relationship between the people, the legislature, and the jury to function as did a democracy, a healthy democracy, which is the people must transform to adhere to natural law, and the legislature must represent the acts of the people, and the judiciary must regulate it. But the point is the people are in charge, and the judiciary just limits them from creating authority that would violate sovereignty and reciprocity. The next thing, I think I've touched on this already, is that I have, haven't I? So the next thing is the ternary logic of the judiciary. They can say, they should be able to say, just like the jury can say, innocent, guilty, and nullified. And with nullified, they can be nullified guilty, and they can nullify a not guilty. The people still decide. So the same is true for the judiciary. They can decide pro, all right? They can decide con, and they can decide it's undecidable. Now, this is different from what the jury can do. It's different. This is the judiciary should be able to return it to the legislature to say this is undecidable. In other words, it's not our job to decide. It's the legislature's to decide.
That would be the equivalent of incalculable?
It's incalculable.
What?
So what happens today is the court overturns legislation, and this is how it's returned. But this doesn't obligate the legislature to fix the problem. What we need is the ability for the judiciary to return an undecidable case to the legislature, who then must reform the law at the consent of the people instead of creating a law. And so this was one of the most important aspects of Scalia's return of judicial empiricism. He doesn't explain all these details, but he's definitely was on the right track. So the judiciary decides by the law, and if that law is bad and produces bad consequences, then the people and the legislature must reform the law. In other words, if there's a difference between a law being illegal and being bad. And if the law is bad, the judge can't fix it. That's a job for the people and the legislature, because they need to learn to behave well. Excuse me, we can't decide this without making new law. Our job isn't to legislate from the bench. By doing so, we reinforce your bad behavior. So we're throwing this back to you, which is to make you demonstrate good behavior, which is to force the market to achieve a reciprocal end.
We're throwing the law out based upon a case.
Well, no, there's two different things. I can throw a law out because it violates the natural law, rights, constitution, whatever. And I can return a law because it's undecidable.
I see.
So I can say for and against the case, and then I can also take the law and say this law is either invalid. In other words, it's a violation of the law. This can't be a law, and you need to reform it, or I can't decide this. So you have the two forms of, two alternatives to nullification, which is this is undecidable for me, then it goes back to the legislature, or this is simply false, or this is decidable one way or the other. So you have right. Pro, con, and undecidable.
And it's not, so it's like this, but it doesn't need a case for them to check that.
Well, that's not always true. So it should go through that before it's ascended into law. In other words, there should be a math check by the judiciary. And honestly, the first 20 things they throw out, the legislature would reform. I mean, because there's just no sense in having your stuff rejected, and if you get rejected too many, more than, I would think of it as a 3 strikes thing. If I'm on 3 pieces of legislation that have been rejected, I'm out of government permanently. Because we ought to really hang them if that's the case. But I mean, people make errors, right? People do make errors. The second thing is that judges can only tell if it's constructed properly, but we're not omniscient. So you could end up with a case coming before the court that would require improvement of that particular law because it doesn't answer the question. And so the judiciary should be able to send it back to the legislature. Right now, this all happens as there's this disconnect between the legislature and the judiciary. It has to go through the public, which means it does all this harm before, and it's really costly before it gets there. And this only encourages malfeasance on the part of the legislature. So what we want to do is remove all that. Look at if it's treason or sedition to propose a violation of natural rights and the application of natural rights of the Constitution. And if you get 3 strikes trying to pass legislation that's faultily constructed, seditiously instructed, you're out of the government forever. So you put those 2 things in place, we're going to have a lot better legislatures. So what am I doing here? So the logic is the legislature, the judiciary, and the law. And first, that judicial interpretation is empirical and textual, such that if times have changed, the legislation must then change. This is what, again, Scalia really brought back to it, is that in the the problem is we don't state the purpose of the law and the conditions of it, but they are obliged to go back into history and understand what the measurements were at the time, not what the measurements are today. And if the measurements are different, then we require new legislation. We don't allow the expansion of the non-legislative expansion of laws. Second, that judicial responsibility is to force the legislature and the people into accountability for their political and legislative directions. In other words, they're not allowed to throw shit over the wall of the court. The purpose of the democracy and the legislature as a democratic institution is to come to negotiated settlements in the market for commons we call the government. And if you're trying to cheat that market, it's the judge's job to throw it back to you so you continue to maintain the adaptability of our civilization and the integrity of the market we call the government as a market for the construction of commons. The third is the whole, and that the whole in our system of government is that the Supreme Court and a monarchy do not need to assent or dissent, veto, or in other words, veto legislation, nor can they return the legislation to the legislature for reformation. We're stuck with this canceling all or portion of it when they should just cancel a portion and return the legislation to the legislature. The court must decide, it mustn't usurp the legislature, but that's the point of positive law, is to usurp the legislature, to create power over the will of the people to come to consensus.